Okay, I think we're good now. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are sitting in this way, all the ordinary rules of oral argument apply, including that each side receives 15 minutes for oral argument with no rebuttal. With that, I'm going to call the first case, which is Commonwealth versus Jonathan Rosario, case number 2020P 0511. And Attorney Leary, we're ready whenever you are.
Thank you. Good morning. May it please the court, Catherine Leary on behalf of the Commonwealth. The Commonwealth would respectfully request that the court reverse the allowance of the motion to suppress statements because the video of the defendant's interrogation reveals that he received full and complete Miranda warnings in his native language, as well as signed a Miranda form in his native language. Here, where there's a video, which I believe the court acted on my motion to transmit, which shows the Miranda warnings given by a Spanish-speaking detective. This court is in as good a position as the motion judge to make findings based on that. Obviously, deference will be given to the findings from the motion to suppress the actual hearing, the evidentiary hearing. But I think if you look at this video, I think it's clear that the defendant had his rights read in his native language. After each right, the detective stops and looks at the defendant and he nods his head, and sometimes he says see, sometimes he says okay, sometimes he says but every time it's accompanied by a head nod after each right, and then the detective goes into the next right.
Attorney Leary, do you agree or disagree that the detective at times did indeed ask some compound questions?
I would disagree with that because my review of the video, along with the transcript translation, is he stops and looks at the defendant and the defendant says yes, and then he goes forward. I don't think that it's just gone straight through. Even if he did do that, I think where a lot of the cases different are distinguishable, and specifically Vasquez, which is cited by my sister in her brief, is that the defendant here had said he could read Spanish, had a Spanish Miranda form, is seen looking at it and reading along with it. The judge even found that. That's at Record Appendix 156, that finding. And so I think where he was read all his rights, even if it wasn't a compound question, which I don't agree with that characterization based on the video, I think it's still clear that he understood his rights and acknowledged each right and understood them based on his initial and signing, and also his outward expression when he's being read the rights.
Do you agree that the better practice would be to ask one question or provide one right, and then have the suspect or the defendant in this case respond clearly, either yes or no? The detective certainly could have controlled that, right?
I do agree that would be the better practice, but here I don't think that makes the Miranda waiver invalid here, or that he didn't understand. I think it's very clear from the video recording, there is absolutely there doesn't appear to be any confusion by the defendant that's manifested at all. So I think where, what happened with the co-defendant, which is not part of the record, I think that might be where it's distinguishable. So I think based on I think the judge cited Commonwealth v. Libby, which is 427 Massachusetts 37. In that case, even though there, I believe, was a Miranda waiver form, there was evidence of confusion in the record about what his rights were, and that he would only get a lawyer at arraignment and not during interrogation. And so I think those are examples where a Miranda waiver form might not be dispositive on the issue. But here, where there's a signed Miranda waiver form, he read it, he said he could read Spanish, he's seen reading Spanish, and after each right is read, I believe the detective does pause and look at the defendant and gets a nod or a yes. I think on this record,
What happens I understand your point about the nodding, but what happens when the translated text is garbled? That's part of the allegation here, which is that the translation of the right was not accurate.
So I have a few answers to that, Your Honor. First, it's not required that the translation be word for word. It has to be able to get the they have to understand the, not really the gist, but they have to understand what the right is and can't be so contradictory.
Sure,
I'm sorry?
but you know, it's a little hard to figure out how that's the case with some of these translations, because the text doesn't really say, I think, what it's supposed to say. What about the one for the attorney? That's very hard for me to understand.
I think my understanding, and I think my sister raised this in her brief, is I believe it's on Record Appendix page 168, where before the Detective Arriaga says, "You have the right to speak to a lawyer who can advise you before we ask you any question." And I believe the video, he pauses and looks up and gets a nod. And to have him with you during the interrogation, do you understand? I believe he pauses, gets a nod in the video. And then if you don't have a lawyer to pay, the state gets you one. Pause, nod. And I feel like that might be the what you think is not clear. I think that based on, I think it's clear that that if you don't have a lawyer, we'll get you. And I know my sister says it could be viewed as, well, if you don't have one to pay, we'll find you one, but you're going to pay him instead of you'll get a free lawyer. But I think where there's no evidence of confusion on that, Amory had the valid written Miranda waiver with that right, which is part of the record as Exhibit 9. I don't think there is confusion there.
Well, but here I think we may run into the problem of the standard of review for you, because you're asking us to do this all sort of de novo based on the video, but the actual translation doesn't depend on the video. This text is what it is. If you don't have a lawyer to pay, the state gets you one. And the judge below made findings about the defendant's understanding. So why don't we need to accept those?
Because I think the video, the judge made findings of the defendant's understanding based on the video and what she watched. I know he averred in his affidavit that he didn't understand, but that's for him to meet his burden to get a hearing. So, you know, I think you don't have to defer to her findings on that he didn't understand, because I think the video is evidence of whether he understood or not, as well as the.
How do we conclude from this text that he understood the right?
I think you look at the video.
We know that he nodded, but if he's told, you have the right to have a chicken represent you, and he nods yes, we would say, okay, he did understand what he was told, but that wouldn't indicate that he understood the actual constitutional right he has.
And I think I would point to the fact that he had the written Miranda waiver in Spanish. He can read Spanish. He's seen reading it. And also, I mean, I would point to, I believe it's cited in my brief, Commonwealth v. Morin, 75 Mass App Court 513. Very similar there, a Spanish-speaking defendant, 20 years old, limited experience in the criminal justice system, and where he had signed Spanish Miranda waiver forms and said he understood, and there's evidence that he understood because he initialed and signed it. I think that alleviates some of that concern. So I understand the point you're making.
How do we know, and I'm sorry, I'm just not sure about this in the record. Do we have a translation of the Spanish Miranda form in the record?
It was not part of the record.
So how do we know that that's correct? How do we know that it says something other than what Detective Arriaga told the defendant?
I think where it's, well, I understand your point. I don't want to say it's presumed that it's correct, because we can't do that. I think that you could compare the transcript as it's translated compared to what the Spanish is on the form. You know, I'm not sure I really have a great answer for that for you, because it wasn't even if you had an English version Miranda form, I don't know if you could say that that was the actual translation. So I understand your point, Your Honor, but
I don't know Spanish, unfortunately, so I can't read that form and say, oh, this accurately reflects any. I mean, I just wouldn't be able to say that. So that seems to me a gap.
yes, I understand, Your Honor, but I do think the video recording does show that the defendant did understand as it's translated. You can see how it's translated from the transcript. And I would like to note from the transcript about there seems to be a little confusion between my sister and I about who provided what transcript. My understanding, based on how it was provided to me by the trial prosecutor and the pleadings below, is the transcript that starts at RA 66 and has Exhibit A on it, was included as part of the defendant's submission of the transcript of the recording of the interview. And in his footnote 1 of his motion to suppress, in footnote 1 of his motion to suppress, it said he appended a transcript Exhibit A. That's RA 66. The transcript is RA 70 to 145. The 3-part translation of the interview, which has Spanish and English on one side, was provided by the Commonwealth. And that's RA 147 is mentioned in the trial prosecutor's pleading, and that's appended. So I don't think it really matters because the judge had both before her. So this court does as well. But I think I just wanted to clarify the record on that, my understanding of the record. And I think when you look at when you look at the video and compare it to the transcript, and I think it's clear that he does understand. And I think, I'm not sure I have much else to say based on that. I think the video does speak for itself. And I think this court, I think the findings based on the understanding are made from the video and the paper transcript, which is before this court. And I think the court is in as good a position to make findings on that as the motion judge.
The motion judge found that some of his answers were and things of the sort. You saw that in her findings, right?
No, I did, yes.
And so for her, she said that was less than clear a response. What do you say in response to that?
I would disagree that that's less than clear. I think when it's accompanied by a nod or a gesture like that is a clear signal that, yes, I understood. And even if he didn't say see or a head nod is a response, it's a clear unambiguous response that, yes, I understand. There's no head shake or look in his face that shows confusion. So I would disagree with that finding, that is ambiguous.
Are there instances where the detective is nodding along with the defendant when he's nodding?
So I reviewed the video, and I believe there's a few instances where he does nod along, but I think the majority of the times he looks up and look, and then as the defendant nods, he nods with him. That's my view of it.
What's the point of that?
I'm not entirely sure. I think that's, I think my sister does cited that people tend to mimic other people, but I don't think that the defendant here was mimicking the detective because he started nodding. My review of the video is that the defendant started nodding before the detective started nodding at him if he did nod back. So.
Counsel, I have a question. At the beginning of the motion to suppress hearing, Judge Fahey repeatedly asked for a signed copy of the defendant's affidavit, but the version of the affidavit that we have in the record appendix is not signed. Do we know if there's a signed copy in the record? And if so, why isn't that included in the record appendix?
Yes, Your Honor. I believe that there is a signed one, and that is my fault because this was the motion that an affidavit I received from the trial prosecutor, and I'm not going to make an excuse because of coronavirus in the courts and everything. So that is my fault. I believe there is a signed affidavit that was given. So I apologize to the court for that not being included as part of the record appendix. If the court is not,
you agree, obviously, well, you agree that the signed written acknowledgement that he received the rights certainly is not dispositive.
No, I would agree with that, Your Honor. But I do think it's a very important factor in finding whether it was an intelligent, voluntary, and knowing waiver of his Miranda rights, especially where he said that he could read Spanish and was seen reading along in the video.
I think
And
it's-
this gentleman was a dropout of high school with no GED.
I don't know if he was a dropout of high school. I'm not sure if that's part of the record. I think even if he were a dropout of high school without GED, I don't think that these are rights. If he can read and he says he can read, I don't think that these are something that would be beyond the ken of his understanding.
What's the best case you have that would stand for the proposition that an articulated verbal response indicating understanding is not required?
Sure. If I could have one moment to make sure I give you the correct case. I believe it's Commonwealth v. Hawley. It's cited in my brief. It's 79 Mass App Court 542. And I believe there, the court found the defendant acknowledged Miranda warnings, understood 3 separate ways. He said immediately following the recitation of all his rights, the defendant nodded when said if he understood. He was told to initial and sign if he under the Miranda form, if he understood, which he did so. And then there's a little extra added there where it says, as he signed, he goes, I know how this goes. So that is a little extra, but I do think that is the best case for the argument the Commonwealth is making. If of course no further questions, I'm happy to rest on my brief. Thank you.
And your time's expired. Let me see. All right, Attorney De Palma.
May it please the court, my name is Valerie De Palma and I represent Jonathan Rosario. As the court discussed with the Commonwealth, the standard of review here is whether or not it gives deference to the lower court's findings of fact, which it can only overturn if they're clearly erroneous. And it reviews the correctness of the Miranda warnings de novo. Reviewed under these standards, the trial court's ruling allowing Mr. Rosario's motion to suppress his statements was correct.
Attorney De Palma, do you dispute whether or not the written warnings were accurate?
I do contend that they were inaccurate, specifically the warning regarding the right to counsel free of charge. According to the translation, Officer Arriaga said, if you don't have a lawyer to pay, the state gets you one. And that's at the record on page 168.
But if we don't have a translation of the written warning statement, how do we know how the verbal transcript corresponds to what was in written in Spanish on the written warning form?
I would argue that we just simply can't, where we, I guess, if you went on Google Translate maybe, but these are things that unless the Commonwealth provides them, because it is their burden, we simply don't have them. The form, I think, is, the Haverhill Police Department standard Spanish language form, but I don't think we can assume from that it's correct. And I think even assuming it were correct, if the verbal warning is incorrect, the written warning isn't going to override it. I think the written warning, the presence of a written form that's signed and executed is not dispositive. It's some evidence of voluntariness. But I think what's controlling is the actual warnings provided by the officer. And if those are wrong, the standard is very strict. They have to convey the Miranda, the gist and the meaning of the Miranda warnings. And with respect to your right to a lawyer free of charge, that didn't occur in this case. Saying if you don't have a lawyer to pay, the state get you one just is not unambiguous. I think it could be interpreted in a number of ways. If you don't have a lawyer or retainer, I'm not really sure what he was saying there, but it simply does not conform to the standard of, if you can't afford an attorney, the state will provide one free of charge. Those don't mean the same thing. So on that ground alone, the Miranda warnings given were inaccurate. Yes, Justice Brand.
I have a question about the record, specifically about the two different versions of the translation of the interview, Exhibit 11 provided by the defense and Exhibit 10 provided by the Commonwealth. It looks to me as though the version provided by the defense has a gap at around page RA 74, where there's no Miranda rights at all included. And this whole business about if you can afford a lawyer to pay, that's not translated at all. There's about a 2-page gap. And the defense attorney's argument below was that the court should not accept the prosecution's transcription because the person who transcribed it was not both a certified Spanish interpreter and a certified court reporter. Now, and it looks to me also from the defendant's unsigned affidavit that his argument was that he received no Miranda warnings at all. So are you still maintaining that argument? Or are you now arguing something different on appeal, that he did get the warnings that the Commonwealth's transcription says he got around pages 167 to 169, but those weren't adequate?
I'll address, well, first with respect to your question about the transcripts. My understanding is, yes, the Commonwealth had a interpreter, someone who was a Spanish interpreter, translate the warnings. Or actually, the Commonwealth's transcript is the one that doesn't contain the translation of the warnings. Their transcript is the one that has the gap. Now, arguably, they should have lost the hearing on that basis, but the defense provided the transcript that contains the translation of the warnings. At the court's behest, the defense submitted it. And defense counsel kept saying, no, it's the Commonwealth's burden, but in the end, he submitted it. That's my understanding.
The one with the 2 columns of English and Spanish.
Yes, that's the defendant's. That's the defendant's. The Commonwealth's is the other one without it. So, because we won, I don't need to argue that they didn't carry their burden, but if I were on the other side, I would be arguing they didn't meet their burden of proof, but I don't have to do that. I won on other grounds, or I didn't win. My trial counsel won on other grounds. So that's the first, my first point. Yes, it is the Commonwealth's burden to provide a transcription of the Miranda warnings, and arguably that would apply to the form. If the form's in Spanish, we don't have a translation that, and they're relying on that form, that should be held against them.
Just so you know, Exhibit 11 is the transcript that does not have the side-by-side English and Spanish. And it pages 108 and 109. Mr. Morris was the defense attorney below, right?
Yes.
And he offers that exhibit at pages 108 and 109. it looks to me as though the one with the side-by-side English and Spanish is Exhibit 10 that was offered by the Commonwealth, and Exhibit 11 that doesn't have any Miranda warnings in it at all was the one that was attached to the defendant's original motion to suppress and then offered at the hearing. So
Okay.
I'm just confused
Okay.
as to whether the defense is arguing something different on appeal than it argued below.
No, I mean, Your Honor, I proceeded on the theory that, and I checked this, and I will check this again. Unfortunately, I don't have the entire thing in front of me at this second, and I'd have to go into my computer, which would be a problem. But I checked, that was the reason why defense counsel didn't want to submit it, because he didn't want to meet the Commonwealth's burden for them. And he was kind of objecting. So, but I will go back and check. I wrote this brief on the assumption that the Miranda warnings were not supplied in the Commonwealth's translation. But I would argue it's not the defendant's burden to prove the correctness of the Miranda warnings in any event, even assuming I got it switched.
But
It wasn't the defense burden to prove. I'm sorry, go ahead.
We have two different transcriptions of the interview, and only one of them contains a transcription or translation transcribed of the Miranda warnings.
That's correct, and they're wrong. That's the thing, we only have one, and arguably the defense doesn't have to submit anything. The defense has no burden in these motions. So the court has the benefit of two, and the only transcription of the Miranda warnings it has are wrong. There's simply that statement about your right to counsel free of charge is incorrect. Is just ambiguous. There's no way I can read that as conveying the right as it's commonly understood. And the point about the defendant's affidavit, again, my understanding is that there is a signed affidavit in the court's record. The one that was provided by the Commonwealth in its brief does not have it. I'm assuming that was the one that it has in its own files, but there was some discussion of it during the hearing. So if the court needs to confirm that, either both the Commonwealth or I could call the clerk's office to ask them to look. And I believe, was there anything I haven't addressed that Your Honor was asking? Circling back to my first point that the warnings were incorrect. At times they were conveyed in a compound manner, which, as we know, when a compound question is asked at trial, we object. And the reason we object is because the answer can never be clear about what we're responding to. And in the context of Miranda warnings, I think, erring on the side of clarity is always beneficial, because we want to know, we can never have enough assurance that someone understands. So separating out each part, which is both the right and the consequence of waiving, is important. In addition, and as Rosario states in his affidavit, the police officer says, now there's 8 of them and I'm going to read them to you. That's confusing, because there aren't 8 Miranda rights. There are 4, and there's 4 consequences. And then there's the so-called 5th, which is neither here nor there for our purposes, but to say there's 8 and then only read 4, that's confusing. And of course, we have to recall, we do know from this record at the very, very end, the officer asked him, so how old are you? He says, I'm 20. And they said, oh, where'd you go to high school? Or it comes out he went to Lawrence High School, but he did not graduate. So this is somebody who, from the record, as far as we know, is young, who does not have a high school education. We don't know where he's from. He's a native Spanish speaker. We don't know if he's Guatemalan. We don't know what country. You know, in many countries, even the idea of having a right is sort of unusual. So I think we have to be careful about what we assume people know and don't know. So saying you have there are 8 of them, is again another factor that adds a lot of confusion to Mr. Rosario's understanding of Miranda rights. And then I'd like to move on to the second part of my argument, which is that he did not. It's that my argument is twofold. The rights were incorrect, and then he did not validly waive them. As I said, he was 20. He did not graduate from high school. He's a non-native speaker of English. And I'd like to point out that the Holy case, which the Commonwealth relies on in its brief, and it also mentioned in its argument, that case did not involve a non-native speaker of English. That person was an English speaker, and that person also had prior experience with the criminal justice system. That was the case in which the court held that nodding would be accepted as a gesture affirming someone's assent. And I think on those grounds, that case is distinguishable from this one.
Well, do you think it was error then for Judge Fahey to preclude the prosecutor from introducing this defendant's criminal record?
As far as I know, she didn't preclude them.
Transcript page 82.
82. I mean, I can check that. I could also tell the court. I mean, if the Commonwealth wanted to, I don't see any basis. I mean, it wasn't part of it. Their argument that his record would have proven that he understood the warnings, as far as I can tell. But I can affirm that as well in a post-argument letter. And I'm out of time if the court has no further questions.
Let me check. No, Attorney Leary, would you please just send a brief post-argument letter stating only whether or not the transcript beginning on page record appendix, I think it's 164, was prepared by the Commonwealth and submitted below. I'll just note that the date of its preparation postdates the date of the Commonwealth's motion, opposition, I should say, by over a week. So, but you'll be able to check.
Mute.
You're mute.
You're still on mute.
Sorry.
That's okay.
I will check that. I
Great.
will check that for the court.
Thank you. Thank you both. It's an interesting case and your arguments have helped us. The case is submitted.
Thank you.
Thank you.
We are live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this fashion due to the ongoing pandemic. Although we're conducting court in this format, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'll call the case of Commonwealth versus a Juvenile, case number 2019 P 1324. And I would remind everyone that this case is impaneled and no one should make reference to any names of the individuals involved. Thank you. And Attorney Rosnoff, we're ready whenever you are.
Thank you. Good morning. May it please the court. Attorney Elena Rosnov on behalf of the juvenile. Your Honor, the juvenile brings three separate issues before the court this morning. The first being whether the motion judge made an error in denying the juvenile's motion to suppress his statements because an interested adult was not present during the questioning. It is important to know that at the motion hearing, the Commonwealth conceded that the juvenile was in fact in custody, so I'm not going to argue that point. The only issue before this court is whether there should have been an interested adult. The trial judge in her decision paralleled the case to Commonwealth versus Edwards and determined that the juvenile statement was coming in due to his own wrongdoing for failing to provide his date of birth. And it is the juvenile's contention that the judge made an error when she did this because the forfeiture by wrongdoing was applied incorrectly. In fact, there's not a case in the Commonwealth where the forfeiture by wrongdoing has ever been applied in an area of Miranda for an adult or a juvenile.
Attorney Rosnoff,
Yes.
so leaving aside Edwards for a moment, there's no dispute that the juvenile didn't provide his accurate birth date. Is that correct?
He testified that he did, but at the time of the motion hearing, which is where the first argument the juvenile brought before the court is that he did not provide his date of birth.
And is there evidence that he did not provide his accurate name?
There was evidence that he gave his first and middle name at
But
the
not his
suppression
last
hearing, not his last name. And again, that's at the suppression hearing. Later at the trial, when the juvenile testifies, he explains why, he uses his first and middle name.
I understand, but we're talking about the suppression hearing at this point.
Yes,
And
we are.
do you take any issue with the judge's finding that the juvenile didn't appear to be a juvenile?
I think that the judge may have needed to make a more distinct findings with regard to that. There was nothing that was brought on the record before the motion judge that talked about the juvenile looking a certain age, that he had, facial hair that made him look older, that he was of a certain size or stature that made him appear older. But also the fact, if you couple that though with the fact that there was actually another juvenile that the trooper was able to speak to, I would take issue of the fact that the judge could have inferred that this was also potentially a juvenile that they were dealing with because it was another juvenile that he was with.
I thought the other person was not a juvenile.
No, that was an error. If that was an error in the judge's finding, the other, and that is actually, that was, I believe in my brother's brief, he did make that correction at the motion stage. And again, I will send the fully non-redacted decision. She made an error. M, who is what is who the appellant refers to in his brief, M is actually a juvenile. And the motion judge.
How old a juvenile?
How old was M?
Yes.
17.
And the officer had that age before speaking with your juvenile, your client juvenile?
There was no issue with the other juvenile giving his name and date of birth, so I wouldn't be able to speculate. He did confirm that M was a juvenile. M wasn't. The only thing M would not do was give the name and date of birth of the juvenile that's the subject of this appeal. The trooper went back and forth between the cars to speak with each juvenile to ascertain, whether the vehicle was in fact stolen or, why they were, seen running from this vehicle. I believe there was evidence that, he was asking the questions to find out maybe the owner gave them permission or there was some other explanation. But It was confirmed that M was a juvenile.
I'm sorry, I'm not certain I understand exactly. I
Sure.
take it the record is not clear whether the officer knew that the other juvenile was a juvenile before speaking with your client?
Correct. The record isn't clear because it according to the trial, so again, at the motion hearing, they don't flesh out how many times the trooper actually spoke with the juvenile in this case. But at trial, it was learned that there was actually 3 or 4, I think upwards of 5 conversations that the trooper had between the 2 juveniles prior to bringing them to the station while they were in the back of cruisers.
I want to switch tacks a little bit. Are you arguing that regardless of any effort that a particular, I'll say juvenile might make, or any characteristics of the juvenile, in other words, absolutely looks older, you know, he's 1 month away from turning 18 and he looks 25, but regardless of any circumstances, there's just a bright line rule about the adult presence? Because otherwise I'm having a hard time understanding what the parameters of your argument might be.
Thank you. And yes, Your Honor, it was brought before the court in the brief that bright line rule is that an adult must be present, or not, I'm sorry, that there's a bright line rule that a juvenile must have a genuine, in this case, because he was over the age of 14, a genuine opportunity to consult with an interested adult. With regard to the parameters, again, what appellate counsel argued in the brief was that there's a slippery slope if you don't do this, in that they'll take ignorance of age and use it as an excuse to question any child. I'm sorry.
Here's a question that's sort of a follow-up on that. Here's a hypothetical. What if a juvenile gives a police officer a fake ID that has a false name and a false date of birth that says the juvenile is 21, that would make them old enough to drink alcohol and to use marijuana?
Well, I would
Would
suggest
that juvenile, if the juvenile really turns out to be 17 and a half, would the trooper be obligated to give the interested adult rights?
I would argue that would be unreasonable, because the juvenile is then taking outward steps to hold himself out as an adult, right? He's producing an ID with a different name and a different age as if he's an adult. In this case, if you crediting the trooper's testimony like the motion judge did, he just didn't give a date of birth.
All right, so that leads me back to my question then. So what I hear you now articulating is not an ironclad bright line rule based on what the age actually turns out to be, but some rule that perhaps ties into objective reasonableness? Correct.
That the trooper, based on his experience, based on what the circumstances that he had around him, which is a stolen motor vehicle, at least one juvenile, having him seeing at least one juvenile run from the car, and then, speaking with both juveniles. I think the wording that was in the brief was, what do we do with a potential juvenile? Do you err on the side of caution and get that genuine opportunity to consult with an interested adult? And I would suggest that, it would have to be on a case-by-case basis. I don't know that, yes, there's a bright line rule that says that when you know that the individual is over the age of 14 and, to the age of 8, under the age of 18, that there is supposed to be this genuine opportunity. But what do you do with can the officer ignore the other circumstances, as I suppose?
I take it, so what you would say is you look at all the circumstances known to the officer and unknown, I guess known and unknown,
Right.
to determine whether what the officer did was objectively reasonable in the circumstances.
Yes.
And all right, and so would you also agree that the fact that the juvenile just refused, he didn't give an affirmative misdate, he just refused to provide his date, is a factor that would be considered in that calculus?
I mean, I would suggest it should be. I mean, given his age, that he has a right not to incriminate himself, right? I don't know that there was ever a real valid waiver of his rights, but I think without the date of birth, I mean, it's hard for he just didn't give it. Well, according to the trooper at the time of the motion, he just didn't give it.
Right.
And then the trooper learned.
I would probably agree that from the absence of information, you may not be able to reasonably infer what his age was, but that wouldn't necessarily lead to an inference that he was a juvenile.
Right. I would suggest that in this case, because like I said, it has to be on a case-by-case basis. In this case, he was with another juvenile, and there really was no testimony at the motion hearing or even at the trial that suggested that that the juvenile looked older or younger than the other juvenile, for example. So very often, there's people refuse to give their names and dates of birth for very obvious reasons. They could have warrants, they could, they just don't want to get into any further trouble. But in this case, the juvenile he is in fact a juvenile, and he was with another.
So other than the fact that he was with another juvenile, what in the record suggests that the officer believed that your juvenile was potentially a juvenile?
There wasn't anything.
Okay. And do we agree that as soon as the officer determined, as a matter of fact, that he was a juvenile, he stopped all questioning?
Yes, he did. I'm sorry, I lost audio. I didn't hear that question, Justice Desmond.
I think you answered it.
Oh, I saw your lips still moving, but didn't hear anything, and I apologize.
There's a time lag.
Thank you. I'm sorry. So if there are no further questions on this issue, I would just like to touch briefly upon the second issue, which the juvenile brings up in the brief, which is whether there was sufficient evidence to establish that the juvenile was knowingly in possession of a stolen motor vehicle. And I would suggest, Your Honors, that the trial, the court rather, or the jury, I guess, could not have made that determination with the information that they had with them. The fact that the juvenile was questioned, a couple of different times over the course of that evening, just because he indicates that he paid $100 for the car and that, he didn't know the car was stolen, doesn't mean that he didn't in fact know he wasn't in a stolen motor vehicle. I think the appellant in his brief points out that the conviction has been secured based on inferences. And it's not that it's impermissible that, or the jury can make a conclusion based on inference, but there's a piling on of inferences in this case, especially, given that the trooper was permitted to testify about the multiple different statements that the juvenile made as to why he was in that motor vehicle.
Well, before we get to the statements, we certainly can consider the flight, right?
And you can consider the flight, but again, the trooper does not say that when he made it to the car, he noticed two individuals in the car and he immediately went back. He doesn't say which juvenile was sitting in the driver's seat of the car. He doesn't say that the juvenile was seen sitting in the passenger seat of the car. I think flight alone although flight can demonstrate consciousness of guilt, I think there are too many other factors that are missing in terms of being able to say emphatically that the juvenile knew that he was in a stolen motor vehicle.
I have two other questions for you.
Sure.
The first is, can you continue to challenge the sufficiency of the evidence when ultimately you're appealing from a continuance without a finding as opposed to a guilty verdict? Do you have any cases that would help answer that question?
I do not, but I would be happy to brief it.
Well, no, it's too late for briefing. The second question I have is, what in your view is, assume we were to conclude that the evidence is sufficient, but we were to agree with you on your first argument about the warning about having an adult present. What is the relief?
Well, if the conviction is overturned, because they're, without his statements, the jury wouldn't have those different stories, and I don't know that there would have been enough evidence presented.
No, but if we were to conclude, as I said, that the evidence was sufficient,
well, that
he would be retried?
I mean, it could be remanded to be tried again, or, if you overturn well, I understand it was a quaff, but his record could be expunged.
No, but what I'm concerned about is, the risk of retrial. So anyway,
Understood.
thank you for your answers.
Thank you.
Attorney Wakeford.
Thank you, Justice Wolohojian. Good morning. May it please the court, my name is Donald Wakeford and I represent the Commonwealth in this matter. The order denying the motion to suppress should be upheld because this is the rare case where the 17-year-old suspect's age was neither known or knowable to the arresting officer. In an unusual case such as this, where the suspect appears for all intents and purposes to be 18 or older, the officer makes efforts to discover his identity and his age, and the suspect thwarts those efforts by providing a false name and refusing to provide his date of birth. The interested adult rule should not be applied to suppress the suspect's statements. I think
Counsel, how do we know from the record that the juvenile appeared to be over 18, other than the judge's observations at the hearing?
Justice Grant, those are the only indications. The judge, as fact finder, opines on the record that I believe during the hearing says he has the appearance, he looks like he's older than 18 to me. He looks like an adult to me. And then in the order denying the motion to suppress, repeats that the juvenile had the appearance of an adult at the time. Is
that a factual conclusion, a expert conclusion? On what basis I wouldn't want to ask us to start guessing each other's names, ages on this Zoom, but how does that happen?
This is sort of what this case is about, is the propriety of making guesses. That's sort of the uncertainty that we are dealing with. It's the kind of uncertainty that the Supreme Court in JDB versus North Carolina says we're trying to avoid in situations like these. The determination made by the motion judge, I believe, is one based on common human experience and the fact that a juvenile court judge is likely seeing a lot of individuals between the ages of likely 10 and 18 on a daily basis. Did
the Commonwealth introduce any evidence of the juvenile's height and weight, or at booking, or whether or not he had a full beard, for example?
I do not believe that evidence was introduced at the hearing, although I would have to go back and take a look at the transcript to see if such evidence was sought or provided.
If we can't rely on a judge's assessment of age as being anything other than a subjective assessment subjective lay assessment. So I don't know how that would be factored into the officer's assessment at the time, especially if it's supposed to be objective, as the Commonwealth argues, which seems to me correct. If we remove the judge's assessment, what then?
Well, the Commonwealth has taken, as I've already referenced, we have taken the sort of rubric provided by custody analysis, which was outlined by the Supreme Court in JDB versus North Carolina. And it centers on what is known or knowable to an officer in the circumstances. Obvious physical immaturity is something that is actually mentioned by the Supreme Court in JDB. So if you had, it's clear that we're not in a place.
Didn't provide any such testimony, correct?
There was no testimony that the defendant was obviously physically immature or obviously physically mature. There was simply
Did the officer offer an opinion as to his own subjective assessment of age?
I do not believe that the officer ever said in his many words, I believed him to be an adult. I believe that was implied by the officer's actions. We also understand that it would not have been relevant because the officer's subjective, subjective thoughts are never going to be relevant in this scenario. It would simply be the objective facts at the scene, which is why we think the juvenile judge's assessment of the relative appearance of the defendant is something that this court can rely on. What we have is the objective circumstances that can be relied upon in each case provide a sort of, as the defendant noted in my sister's argument, a sort of factually flexible and case-by-case analysis is possible when you are looking to the objective circumstances of each case. It's not simply that the suspect in this case had the appearance of an adult. It was also that there was nothing to indicate to the officer, no circumstance that would have made it known or knowable that the juvenile was in fact a juvenile. He wasn't apprehended at a school. He wasn't, there's no evidence he was obviously physically immature. And in fact, the judge's comments indicate otherwise. And there was no identification provided. And in fact, when the officer sought to identify—
Who had the burden on the issue?
On which particular issue are you
on whether of ascertaining, who has the burden to ascertain the suspect's age?
Well, that's the question that we come to, where there's no case specifically on point which determines in this specific scenario who is left with the obligation, so to speak. And that
assume that it's the Commonwealth, and assume also that in this case, at least, there's no testimony from the officer concerning observations he made about this particular person that would bear on age, because that's the case, right? He provided no testimony about the characteristics of this juvenile.
Well, he provided testimony that he believed the juvenile made a voluntary and knowing waiver of his rights, and that testimony was credited not just by the motion judge, but also the trial judge in pretrial voir dire, and also by the jury, who was instructed that if the juvenile's statements were provided non-voluntarily, that they should not be, beyond a reasonable doubt, that they should not be credited or they should not be considered. So the officer testified that he believed that the juvenile gave a knowing and intelligent waiver of his rights. I suppose if you're saying that, if it's the Commonwealth's burden to establish the age, and the officer did not provide testimony as to what he believed the age was, is that what Your Honor is asking the Commonwealth to clarify?
My first question to you was, who has the burden to ascertain the suspect's age?
We believe in a scenario specific to this, and this is a corner case.
Maybe we could start with a case. rather than just beliefs? Is there anything that would, ordinarily the Commonwealth has the burden of proving voluntary and knowing waiver of rights. So I'm assuming it would be this also the Commonwealth's burden to establish that the person they're interviewing was not entitled to the warning of interested adult.
Yes, Your Honor, it is the Commonwealth's burden to prove that beyond a reasonable doubt that a statement that a waiver is voluntary. It is also the Commonwealth's burden to show that warnings were provided and that a waiver was voluntary, especially in a juvenile setting.
Okay, so we know that this particular juvenile did not receive the warning about having an interested adult present. So, so then you're asking us to carve out an exception where it, I guess, appears objectively reasonable that the officer wouldn't have known that this was a juvenile.
Yes, Your Honor. What we are.
And so what I'm asking is, what evidence did the Commonwealth then introduce of this particular juvenile's age at the suppression hearing that would have informed, that this, because if you're asking us to say it was objectively reasonable for this officer to think that this juvenile was over 18, we need to know what the foundation for that objective belief would be, the factual foundation. And I understand that the juvenile didn't provide an age, but I don't know that you can from that refusal infer that what age he is.
I think then we are left to come back to the judge's statement, the judge who had the opportunity to view the juvenile and who was making a judgment based on common experience that the juvenile plainly had the appearance of an adult. The juvenile was also apprehended after fleeing from a stolen car at 11 o'clock at night, which would certainly give rise to an assumption that the person you're dealing with is more likely to be an adult than a child.
Why? Kids flee all the time, don't they?
It's true that it happens, Your Honor. We are simply trying to assess whether there was a permissible understanding based on what was known or knowable to the officer that he was dealing with an adult.
Should the officer's suspicions have been heightened when the juvenile told him he bought the car for $100? That strikes me as a juvenile response.
I don't know that response could be characterized as technically a juvenile response. It certainly seems like a desperate attempt to provide an explanation. This was after the juvenile had refused to provide his name. So this was, and actually had provided, I believe, several false names was the testimony. So the officer's understanding at that point could have been that this was just a person who was trying to avoid accountability, avoid getting in trouble at any cost.
And by suggesting he bought the car for $100 off the street, that was going to do it?
I'm not saying that it was a wise course of action, but I also don't know that gives rise to the assumption that this is a juvenile that I'm dealing with. I think the uncertainty is part of the question, where are officers expected to guess the age of the person they're dealing with, where the age is not known or knowable. That was the scenario facing the officer in this case, where he immediately provided Miranda warnings to the juvenile, which is not disputed, and received an otherwise permissible or an otherwise valid waiver of those rights. He then proceeded to try to identify and ascertain the age of the juvenile in order to determine whether additional rights or warnings should be provided, and was thwarted by the very actions of the juvenile. So I don't know that we are necessarily asking for an exception to a clear rule, because this is not a scenario that has ever been considered by a court in this Commonwealth based on research by both the juvenile and the Commonwealth. Instead, what we have is a situation where the juvenile's own actions made it impossible for the Commonwealth to ascertain the information required to trigger the provision of the rights that the juvenile now complains were violated. The Commonwealth's position is simply that the juvenile should not be able to then say that the interested adult rule requires the suppression of statements when it is the juvenile's own actions in the totality of the circumstances which made it impossible for the Commonwealth to abide by that very rule. And we think that because custody analysis, which is the analysis that police officers are told to engage in to determine whether Miranda warnings should be provided in the first place, is already one where we make an assessment where age is considered only where it is known or knowable to the officer. That is simply what we are asked to what we are asking to be applied in this specific situation, which again we do not believe is going to be common. And it seems like the body of Massachusetts case law indicates it is incredibly uncommon. So because the police already have this tool available to them and are already trained in this sort of assessment, where we have all of the factors specific to this case, including the immediate provision of Miranda, the otherwise valid waiver, and the attempts to ascertain age, and the ceasing of the questioning once age was actually known, that it is not reasonable, and the touchstone of Fourth Amendment, of course, is reasonableness, for the interested adult rule to lead to the suppression of statements in a case like this. We simply would seek to avoid a scenario where suspects can refuse to provide their age, and then officers are before any interrogation can take place, are having to engage in the type of guesswork which the Supreme Court has specifically said we want to avoid in this setting. It would mean that any suspect who has the possibility of being a juvenile and refuses to provide basic booking information at the scene would have to be taken in for booking each and every time to determine their age before any questioning can take place. The Commonwealth believes that the tools are already there, that the motion to suppress in this case should be upheld because the basic reasoning for an objective assessment of the reasonable actions of the police officer are already there.
We understand your argument. Thank you. We understand your argument. Justice Grant has a question.
I noticed that the suppression hearing happened about 7 months after the crime. In a scenario, and that was the judge's opportunity to observe the juvenile. In a scenario where the suppression hearing happened, and in fact, by the time of the suppression hearing, the juvenile was in fact 18. If there was a delay there, what would the time frame be when it would still be reasonable for us to rely so heavily on the judge's observations of the juvenile's age?
Certainly, I think that's going to depend on a particular case. And if this is the type of evidence that is going to need to be brought about with a greater specificity going forward, that's something that the police will probably need to know, because certainty in these scenarios, in these circumstances, is very important. I think because in this case, the juvenile was close to the age of 18 when this occurred, I believe 6 months away from his 18th birthday when this interaction occurred, that it would possibly be given less weight than if you had somebody of a younger age whose appearance could have radically changed, probably more in the ensuing 7 months. Just the closeness to the age of 18.
We're going to have to leave it there. Thank you.
Thank you.
It's a very interesting case. We've been helped by both of your arguments. We appreciate this appeals court, which we are conducting in this format because of the ongoing pandemic. Although we're conducting it in this way, all the ordinary rules of argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Jason HALTIWANGER. I hope I've pronounced that correctly. Case number 2020-P0517. And I will just note that the case is partially impounded. And so we should be aware of that in terms of referring to names. Thank you. Attorney Booker, we're ready whenever you are.
Thank you, and good morning, Justices. Thank you very much. I am Mark Booker. I'm here for the appellant, Mr. Jason HALTIWANGER, and as the court has the parties' briefs, I won't rehash everything that's in our brief, but I'd like to start with the proposition that the two constitutional errors that pervaded this trial, namely the failure of the court to have conducted a competency hearing in accordance with due process of law related requirements, and the failure of the court during the waiver of counsel colloquy to have inquired into Mr. Haltiwanger's mental state and his competency in particular. Either of those errors standing alone would warrant a new trial. Together, they warrant a new trial. And they also, as I said, inform and pervade the several other errors that occurred during the course of the trial. Mr. Haltiwanger, as the court can see from our briefs and from the submissions, was before the motion judge referred to in our brief on several different dates leading up to the trial. June 6 in particular, 2019, June 10, 2019, and June 11, 2019. And what's notable is that by the June 10, 2019 hearing, Mr. Haltiwanger's fourth privately retained counsel was moving to withdraw. At that time, the motion judge inquired of the soon-to-be departed counsel, withdrawn counsel, I should say, whether Mr. Haltiwanger was competent, whether that counsel had any doubts or concerns whether Mr. Haltiwanger was competent to stand trial. And the departing counsel at that point indicated something in the negative, that that counsel had no concerns. I believe it was, quote, since last Friday, close quote, referring to a preceding hearing that had occurred before the motion judge. At that point, the motion judge permitted Mr. Haltiwanger to tender a written waiver of counsel. That's part of the record. And you justices will note that Mr. Haltiwanger purported to sign that without prejudice and misspelled the word prejudice, ending the word with an S. Notwithstanding that, the motion judge accepted that waiver, but ordered Mr. Haltiwanger to return the next day, June 11, 2019, to submit to a competency evaluation under Chapter 123, Section 15A. As I've laid out in our papers, and as the record demonstrates, the motion judge heard the next day from the court clinician, Dr. Richard, that in substance, that Mr. Haltiwanger refused to submit to the evaluation. And with that, the motion judge said to Mr. Haltiwanger, "I'll see you here Monday for trial," referring to June 17, the upcoming Monday. And at that point, Mr. Haltiwanger, faced with an indictment that charged him with trafficking cocaine, 100 to 200 grams, in which he was facing a minimum mandatory sentence of 8 years in state prison, went into his own trial 6 days after having refused the competency evaluation, without any findings about competency and without any full hearing on competency as is required under the cases from the United States Supreme Court, from our Supreme Judicial Court that date back to Pate versus Robinson in the United States Supreme Court, that date back to Vales in the Supreme Judicial, at least to Vales and Hill, and marched into his own pro se trial.
What is our standard, sorry,
Justice.
what is our standard of review? And I want to focus here in particular on the June 10th hearing.
Yes.
What is our standard of review where a defendant does not challenge competency at that point in time?
Well, thank you for that. The issue is that as the Supreme Judicial Court pointed out in Hill, it would be peculiar indeed for there to be a waiver argument to be made against Mr. Haltiwanger in these particular circumstances, because, of course, if Mr. Haltiwanger is not competent to stand trial, then he's certainly not competent to waive the issue of competency. And so I believe that this court's review should be plenary on the subject. This is a constitutional.
He had counsel present at that hearing.
At the June 11th hearing, Judge?
At June 10th.
Excuse me.
June 10th. And no one raised competency. And I'm not asking about whether he was capable of waiving it, but it was waived because no one raised it. And the question is, what is our standard of review?
Right. Well,
is it substantial risk of a miscarriage of justice?
No, I don't believe so.
What's your best case for that?
Well, my best case is Hill, actually, because Hill talks about the idea that it is paradoxical and unfair in the circumstances where there's a substantial question of possible doubt about a defendant's competency to subject the defendant to a potential waiver of that. The motion judge himself, sua sponte, as was his duty under the law, raised the issue of competency. So the motion judge raised the issue of competency, asked departing counsel whether that counsel had any doubts about Mr. Haltiwanger's competency. And the motion judge himself, after having heard from that departing counsel, ordered Mr. Haltiwanger to return the next day for 2:00 in the afternoon on June 11, 2019, to submit to an evaluation. So the motion judge invoked the statutory authority under Section 15A, which is premised on the motion judge's perception that the motion judge has a doubt about competency. So here we're even past the legal question whether there was a substantial question of possible doubt. Here, the motion judge implicitly indicated that he doubted competency. In fact, he said that in the transcript at the hearing, and it's reflected in the transcript that he had a question about Mr. Haltiwanger's competency and therefore ordered him to return for that evaluation. Now, the other problem with that is that by that point, Mr. Haltiwanger no longer had counsel when he came back on June 11, 2019. And a forensic evaluation under Section 15A is a critical stage of the proceedings where Mr. Haltiwanger was constitutionally entitled to have counsel. And the United States Supreme Court has said in Estelle versus Smith, the citation is 451, United States 454, it's a 1981 case, that a forensic evaluation is a critical stage of the criminal proceedings, and the court must inform the defendant and counsel of the purpose of the evaluation and afford the defendant and counsel the opportunity to consult as to whether the defendant should submit to that evaluation. So when Mr. Haltiwanger came back without a lawyer the next day on June 11, 2019 for that evaluation at that critical stage of the proceedings, Mr. Haltiwanger lacked the benefit of having anyone trained in the law counsel him, an attorney counsel him about whether to submit to that evaluation and whether it was in his interest to do so.
How are we supposed to understand what happens on the first day of trial? At that point, the defendant shows up with counsel. Counsel seeks a continuance, but doesn't raise any concern about competency or waiver of counsel.
Okay, so at that time, that attorney, and I believe it was Attorney Atwood, walked into the trial session with Mr. Haltiwanger and indicated that he, the attorney Atwood, was entering a limited appearance. And the judge permitted him to do that. And then Attorney Atwood, in substance, pressed the motion to continue the trial date. There, I don't believe, is any fair indication in the record that Mr. Atwood had any extensive interaction with Mr. Haltiwanger, that he knew him well. And I don't think that there's anything in the record that can fairly support an inference that Attorney Atwood had a sufficient opportunity to be with Mr. Haltiwanger or communicate with him to assess Mr. Haltiwanger's competency to stand trial.
You have the burden in terms of establishing whether or not at that point there's not a valid waiver.
I beg your pardon, Justice?
Who would have the burden to establish that at that point there's not a waiver of the arguments that you're making now?
Well, the issue is that actually, and this, I think this animates both parties' briefs. A really, I think, closely allied question to that, and I'm going to answer your question, Justice Wolohojian, this way. The Commonwealth bore the burden to prove by a preponderance of the evidence that Mr. Haltiwanger was competent to stand trial after the motion judge raised the issue of competency. And that burden, the motion judge never actually allocated to the Commonwealth and never put the Commonwealth to satisfying. So by the time Mr. Haltiwanger walks in on June 17, the morning of his trial, the Commonwealth have not at that point satisfied their burden to prove by a preponderance that he's competent to stand trial. And indeed, here we are in this posture where the Commonwealth is asking this court now to act as fact finders and to determine that the record reflects that, based upon Mr. Haltiwanger's demeanor at trial and his performance at trial, that he was competent. But that approach has been repudiated going back to Hill. That retrospective analysis of the way that the defendant behaved at the trial was firmly rejected in Hill and has been firmly rejected since then. And it would put this court in the improper function of fact finder on the issue. In fact, the motion judge was present with Mr. Haltiwanger in the courtroom on, I believe, 4 different dates in June. 3 of them readily come to mind: June 6, June 10, and June 11. And based
Counsel,
on,
did Judge Moriarty ever make a specific finding that there was a substantial question of possible doubt as to your client's competency? Are you inferring that from the fact that he referred him for a competency evaluation?
yes, I am inferring that. I believe that it is a fair inference that when Justice Moriarty invoked the mechanism of Chapter 123, Section 15A, that according to the statute happens when that is authorized to happen under the statute when a judge has a doubt about a defendant's competence to stand trial. And so that was the mechanism that Judge Moriarty invoked, and that's what happened as a consequence, was that that evaluation was set up.
So would that mean that anytime a judge refers someone for a competency evaluation, let's say the judge is just doing it just to be on the safe side, if the defendant then refuses to participate in the competency evaluation, would the judge then be required to find that he's not competent?
Oh no, I don't think that follows at all. I don't think that follows at all. But what is black letter law is that when there's a substantial question of even possible doubt, that the judge must, under the constitutional cases that we have from the United States Supreme Court and from the SJC, must then hold a hearing. Here, no hearing happened. There's no evidence at all in the record that the burden was properly allocated to the Commonwealth to prove competency by a preponderance.
What's the substantial question of possible doubt based on? Is it these statements about you're denying me subrogation?
Well, I don't know. That's a good question for the motion judge. The motion judge was there in the courtroom with Mr. Haltiwanger on these various dates leading up to the trial. And based upon, I can only assume what the motion judge heard and what the motion judge saw, determined that he had a doubt about Mr. Haltiwanger's competency. He said so, and then he invoked the procedures under Chapter 123, Section 15A. And at that point, at the point that he did that, that reflects that he had that doubt. And because he has that doubt, he is constitutionally mandated to hold a hearing. And it can't be, it certainly can't, our position is that it cannot ever be sufficient in these circumstances to say, well, I'm not going to put the Commonwealth to their burden to prove competency by preponderance, and I'm also not going to hold a hearing. I'm just going to say, if, upon hearing the defendant, that the defendant without counsel at that point refused to submit to the evaluation, I'll see you here Monday for your pro se trial in a trafficking case. That's not fair, and that's not due process. And that's what happened here. Likewise, for the waiver of counsel, there was no inquiry at all at that point into Mr. Haltiwanger's competency. And during the very same hearing, the judge expressed a doubt about competency, yet omitted any references to mental health or mental state during the waiver of counsel colloquy. And in fact, put the cart before the horse by permitting Mr. Haltiwanger to waive counsel before his competency had even been established. That's also not right, and that's an error of constitutional magnitude that's structural and that isn't subject to harmless error analysis.
I think we understand your argument. Let me see if there are any other questions. No, I don't see any. You still have 20 seconds remaining. Do you have anything you want to add?
Well, just that the other minor errors that happened, relatively minor, I should say, I think illustrate the problem with this. The Commonwealth now concedes that the evidence on the Class E pills was insufficient as a matter of law. Mr. Haltiwanger didn't know that because he doesn't know the law, and he wasn't a good lawyer for himself because he's not fit to do that. And with that, I'll yield. Well, I'll mute myself, I should say.
Thank you very much. Attorney Kenny.
Thank you. Good morning. May it please the court. Jessica Kenny on behalf of the Commonwealth. I'll get right to the court's question about competency. It's still the two-pronged test and the post-conviction test when it's not been raised at trial. It's in my brief. It requires the defendant to establish by a preponderance of the evidence that the Commonwealth would not have prevailed had the issue been raised at trial, and that's the Chapman test. And so it's the defendant who bears the burden of establishing that if the issue had been raised, the Commonwealth wouldn't have prevailed. And I did cite to a case that says it is perfectly acceptable in these situations to look at the context of the trial and the way that the defendant performed during the trial. I'll start with before the trial. He had 5 different lawyers, if you count Mr. Atwood's brief appearance. And I disagree. Mr. Atwood indicated that he did speak with him on the phone for about 45 minutes, that he spoke about his case, and that he also had a conversation with another attorney, Mr. Reddington, who knew about the case, and they spoke about the case. And further, Mr. Atwood indicated on the record that what the defendant told Mr. Atwood about the case was consistent with what a trained attorney, Mr. Reddington, told Mr. Atwood about the case. So right there is evidence that the defendant knows what he's talking about because he's consistent. But you have these 5 attorneys plus a standby counsel who's present during the whole trial, and not one of them raises the issue. And it's not.
That may get you, I take your point. That may get you through the trial. I want to focus on the June 10th hearing, if I may, if I have the date right. That's the hearing where the judge both raises his own concern about competency, but at the same time accepts a waiver of counsel. Do you have a case where we have upheld a waiver of counsel when a judge has had a simultaneous concern about competency?
Well, I don't know that we would say that the judge has a concern, and that I think that goes back to Justice Grant's point, is the judge just might have been trying to protect the record here. And we do know that after the defendant refuses, the judge basically goes through a recitation of the file, and you can tell that the judge has now at this point looked very in depth at the case, as well as some new pleadings that were filed by the defendant, which are, I think, very important. It's the Commonwealth's position here that there never actually was a true question of competency, not only because it wasn't raised, but because even when you look at some of what you might consider the confusing statements the defendant was making, and maybe some of the confusing pleadings, as the Commonwealth articulates, and as is shown in some of the attachments in our record appendix, which I'm asking the court to take judicial notice of, these are unorthodox legal thinking, but it is a scripted defense. It is.
Is there anything to indicate that the judge knows that on the date that he's ordering the defendant
Again, I
under
would indicate
competency?
Sorry, I didn't mean to interrupt you.
That's okay.
He has indicated that he's gone back through the file and he's reviewed everything in depth and in great detail. And again,
that's after June 10th. I'm talking about June 10th.
So I think on June 10th, again, perhaps the judge is a little concerned because of some of the statements the defendant's making about the subrogation and about.
And based on the previous appearance on
Correct.
June 6th, and he asks his lawyer, and his lawyer says, well, I haven't had a concern since June 6th, when there was an incident in the courtroom.
That was the day he was fired.
Right, exactly.
So I think he's basically saying, I can't speak to anything that's happened since I've been terminated as his attorney. I don't think it was in direct response to the case, because you'll recall on that day, on June 6th, the attorney says, look, I think he's just reluctant to go to trial. He's turned down the Commonwealth's offer. You know, he sees what's coming and he's just reluctant to go to trial, in essence saying that he's dragging his feet. Still no indication there. And I think that statement is not based on the way that the defendant was acting at the hearing, but rather recognition that I stopped representing and communicating with him on the 6th. So I can't attest to any, his mental status since that date. I don't think that it's a statement about his behavior. But
so notwithstanding that response, the judge still orders that he be evaluated. And the response he gets after the evaluation is that he refused to engage in any evaluation. So what's the judge supposed to do then? He's just supposed to move on?
Yes, I mean, this is the defendant's tactic. He's being disingenuous with the court.
I understand now we can argue that, but in real time, what is the judge supposed to do if he has a legitimate concern? Assume for the sake of discussion that it wasn't a tactic. If he has a legitimate concern with somebody's competency, and that arguably incompetent person refuses to be evaluated by the court clinician, what's the judge to do?
I think at that point, the judge could order him to an inpatient if the judge was legitimately concerned about his ability to be competent. I think the fact that and Judge Moriarty knows that. I mean, he's been a judge for a very long time. He's obviously aware of what's going on and the rules that are available to him to ascertain this. And he certainly could have ordered the defendant to an inpatient facility for the 20-day evaluation pursuant to the statute and delayed the trial again. But that is exactly what the defendant wanted. And I think at that point, when Judge Moriarty—
Can he validly do all of those things? I think in my mind, the question is, can he validly take a waiver of counsel during the period that he holds a doubt about the defendant's competency? And I'm not asking for your opinion about that, but a case
that says that he can allow him to represent himself at that time.
he can take a waiver of counsel, a valid waiver of counsel, at the same time he holds a doubt about the defendant's competency.
I don't
And
believe—
the defendant is unrepresented at that point in time.
I don't believe that he could do that, but I think that that shows that he
Again, I'm
doesn't
looking
have—
for a case, Attorney Kenny, not a point of view.
I understand, and I'm conceding that I don't believe that there ever would be a case that says a judge could take a waiver from an unrepresented and incompetent defendant. But again, I think that—
So right now you're asking us to somehow conclude that the judge's actions at the time were either mean something other than what on their surface they appear to mean.
I'm suggesting that they show that the judge actually did not question the defendant's competence, that this is more of a perfecting the record situation and asking the defendant to undergo the evaluation. And at that point, when they come back to court and the judge has now had the opportunity, as he describes in detail, to review the file and to go through the pleadings and to look at the new pleadings the defendant was filing that are all of the sovereign citizen, talking points, realizing again that the defendant, as he found, was just attempting to manipulate the court. And we know that that's what he believed at the time he ordered the defendant to trial, because he said it. He said, you've done nothing but manipulate this court. You've done nothing but delay this trial. And so that is his finding. Again, you go back to Justice Grant's point. If a defendant refuses to participate, even if they had sent him for the 20-day evaluation and he was inpatient, he refuses to participate, he doesn't get to eternally delay his trial because he won't comply with the order. The court is allowed to look at the defendant's behavior, to look at the record, to look at what all the prior attorneys have said, and to find, as he did, it's supported by the record, that all the defendant was trying to do was manipulate the court, delay the trial. It's exactly what his own counsel said.
That finding was made when? That finding was made after the date we're talking about.
After the date that the defendant refused to be—
After the date that the defendant waived counsel.
Correct. And I think that's the point. I think even having the benefit of the fact that knowing the defendant was not going to submit to the evaluation, I mean, if anything, doesn't that almost prove his point? Because he refuses to submit and the judge says you're held for trial, and then the defendant threatens to sue the judge based on that. So it's all this vindictive. I think that it helps that the judge made that finding after he knew that there was not going to be, remember, in conjunction with this, he's refusing to be interviewed by probation.
Better or for worse, for better or for worse, we will review the correctness of the judge's decision based on what was before the judge at the time the judge made the decision. So looking at post hoc events is very difficult when the analytical framework is to review the judge's actions through the prism of what the judge knew at the time.
wouldn't it have made more sense for the judge to make those findings that you're referring to prior to saying, see you on Monday for trial?
I don't know. I think it just, I mean, could it have? Sure, but who knows if the judge was expecting the court to, to happen the way it did. It might have been that the defendant refused that evaluation, and then the judge went back as he should have and looked at the record and said, what can I do here? What should I do here? And then made a very thorough and thoughtful evaluation of the record. I understand that the court is sort of set at this point in time with Judge Moriarty in the motion session still, but the case law does support that in a situation such as this, where it's not raised by a defendant, it's not raised by his lawyer, that the court can consider the contemporaneous trial and the things that happened during the trial. And I understand that you're considering the correctness of the judge's decision, but one of the things that you now have to see if the judge is finding that he was just manipulating the court and he was just trying to delay things is the fact that there was a multiple day trial. And my brief in many of the references cite to all of the things that the defendant did during the course of the trial that show that the motion judge, Judge Moriarty, was correct when he found that there was no actual competency issue and that the defendant was just malingering and trying to delay what was at that point the inevitable. And he was just trying to get his case dismissed based on some unorthodox legal principles. And he was just saying the things that he had read and was told to say to get his case delayed and or dismissed. We do have the benefit of that. And you have a defendant who was very involved in his case, who many times the judge made reference to him understanding principles, to him speaking with his counsel. I think it's important to note that this court just issued a decision on Friday where it was reversible error because a judge did not allow a defendant to represent himself in the middle of a trial right before the bifurcated portion or subsequent offense. A defendant indicated he wanted to represent himself. The judge denied that request, and this court found that was reversible error. So you really put, both these judges, the trial judge and the motion judge, in a difficult position where a defendant has an absolute right to represent himself.
Right, but the defendant here initially stated that he wanted time to get another lawyer. His first choice was not to proceed with self-representation.
The first thing the defendant said was, I'm going out on my own. He did not ask for more time to get another lawyer. In fact, he didn't want another lawyer. He repeatedly said he wanted to go out on his own. The judge asked him to consider that, to think about it, to speak with his attorney, gave him the weekend to do so. He came back after that weekend and reaffirmed, I want to represent myself. I want to go on my own. Refused to be interviewed by probation to see if he qualified, refusing to have a counsel appointed. Obviously, he was given standby counsel and he ended up utilizing him throughout the trial. But it was the defendant who wanted to represent himself, and he repeated that multiple times. And again, it was just really an attempt to delay the trial because I think he thought that the judge wasn't going to force him to trial on his own or without filing, quote unquote, his motions that he's never articulated. Yes, Justice Grant, I'm sorry.
What authority do you have for the proposition that we can take judicial notice that some of the unusual things this defendant said had to do with the sovereign citizens movement? I thought judicial notice was for easily verifiable and uncontestable facts like February 1st is a Monday.
So I think if I were asking this court to take judicial notice of the principles of sovereign citizenship, obviously that would be quite problematic. But because I'm asking this court just to simply take, not for the truth, but for the fact of their existence, I think it does fall under that generalized knowledge. Again, I'm not suggesting obviously that it's proper. I'm just suggesting that as I did, anybody can Google the expressions that the defendant was using, and there are web page after web page of literally verbatim transcripts of what the defendant is saying. And I'm not saying that what he's saying is correct or that it's proper law. I'm just saying that it demonstrates his ability to do his own legal research, to understand it, to memorize it, and then to say it at the appropriate times, hoping to get the outcome that he thinks he's going to get because he's utilizing it. Certainly, I think that's why it's okay, because it's just the existence of it and the fact that it's available only to counter the defendant's argument that it shows that he is actually confused and doesn't know what he's doing. It's quite the opposite. He might not be correct, but he understands what he's doing, and that is trying to get his case dismissed.
So if we had a defendant who was saying bizarre things before trial based on a religious belief, for example, it would make a difference whether that religious belief was widely accepted enough that it was Googleable. And if it's only his own religious belief, it's not Googleable. We can't take judicial notice of it. And so one defendant's going to be competent and the other one's not.
No, and I think it's a very distinct, because again, it's not about your religious beliefs or anything like that. It has to do with a legal defense, and only because it specifically deals with a legal defense. And if you see some of the attachments, it says, hey, here's how to get your case dismissed. Here's how to make it so that they can't prosecute you. And these are the step-by-step things that you need to do. And then the judge clearly can't find you, can't hold a trial without your consent. You need to say these words. You need to spell your name this way. So only because it is a legal defense that he believes is probably viable, that I think that it's in this circumstance appropriate for the court to consider it generalized information. Again,
How do we make the evidentiary record on appeal that what you Googled in preparation for your brief, was what was available on Google at the time that the defendant was speaking at these various hearings, A, and B, that the defendant Googled and got the same pages you got and based his statements on them?
Again, Google's obviously, what I used during the pandemic while I was, writing this brief.
Well, you're asking us to take judicial notice of an awful lot of things, and I think this is just repeating Justice Grant's question, then your time is up, so you don't need to answer.
Okay.
All right, thank you both. It's
Thank
an
you.
extremely interesting case. We've been very much helped by both of your arguments, and the case is submitted.
Thank you.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this fashion due to the ongoing pandemic. Although we're conducting court in this manner, all the ordinary rules of argument apply just as though we were conducting court in a physical courtroom. And that includes that each side gets 15 minutes to argue with no rebuttal. With that, I'll call the case of Jennifer Bettencourt versus Kevin BIORCI, case number 2019 P1617. And I'll remind all counsel that the case is partially impounded, and so we should all refrain from using names. And we are ready for you, Attorney Army, whenever you are.
Thank you. May it please the court. Lawrence Army Jr. for Appellant Kevin BIORCI. The trial court made a critical error of law when they rendered a decision based on a scientific finding without first having considered any scientific evidence. In this case, the father was deprived of his legal and physical custody rights, his constitutionally protected rights to parent his children, based upon the trial court's finding of parental alienation.
Mr. Attorney Army, I'm just going to interrupt you for a second because it appears from your brief and from your opening here that it's your belief that the judge's finding hinged predominantly on alienation. Is that in essence your argument?
Well, I don't think it's my argument as much as I think it's what the judge said in his rationale and in his judgment. But yes.
When I read his judgment, I see that he refers to the therapist and the GAL as believing that father has engaged in parental alienation. And I see that he says the court finds that it's more likely that the father, or the court finds that it's likely that the father used such language in the children's presence. But he talks a lot about in the beginning, the father's decision-making capability does not allow him to make decisions in the best interest of the children. And that has nothing to do with the alienating stuff. So again, I ask, is it your belief that his findings hinge predominantly on this alienation theory?
Yes, I do.
Okay.
And I think you make an interesting distinction here that the father's, what you mentioned about the father's ability to make decisions when it relates to the children. And again, in this particular case, we have joint physical custody and joint legal custody that we started with. I think what your point, Justice Desmond, it goes to the issue of legal custody, the ability for two parents to get together and to make meaningful decisions based on the child and where the children are. What I'm focused here for the most part is going to be on the physical custody, because I believe that the Daubert case, Daubert v. Merrill, clearly states that expert testimony, expert evidence, doesn't have to be testimony, it could be a treaty or other evidence, is required for the link of causation between alienating behavior, which the judge found here and laid out, and the causational root between the psychological damage of parental alienation that he insinuates, and quite frankly, put in his judgment that existed here.
You would agree that the judge could make, and you don't challenge the subsidiary facts found by the judge?
I don't think we need an expert to find the facts that the judge found.
Sure. So you don't need an expert to find in order for the judge to find the facts that may or may not bear on alienation.
Correct.
The judge could find those facts.
Correct.
So your quarrel is to the extent that the judge made a conclusion of alienation, and that may be subject to our own review of the judge's decision to see if that actually occurred. Your quarrel is with the link between the subsidiary facts and that conclusion. Is that correct?
That is correct. And I believe the Daubert case, and as Massachusetts has brought it in under the Lanigan case, would require scientific expert evidence to form that link between behaviors and then the mental issue of alienation.
So if we were to disagree with your reading of the judge's decision, and we were to conclude that it doesn't hinge on a finding of alienation, what then?
Well, then I think we have to look at an abuse of discretion, and we look at each of these items. And I don't think, quite frankly, any of them, having been in the probate court for 25 years, rise to the level of terminating a person's custody from their children. We can go through these things, but if we start with the language, which Desmond talked about earlier, I have a couple issues with these things individually versus as it relates to my main argument that there is expert testimony, expert evidence, scientific evidence that's required to form that link. Because if we look at the judge's rationale, it's clear from his rationale that he looked at what the GAL and what the therapist said as parental alienation, despite the fact that neither were brought in as an expert, neither were given notice under the pretrial conference memo that they would be brought in as an expert, and neither testified as an expert. In fact, the GAL was a category F versus E, and they're not even allowed to make any kind of determinations such as parental alienation, which I would suggest every single day in the Commonwealth, family law attorneys are dealing with issues such as parental alienation in these cases, and it's one that this court would be well to give us some guidance on, because we're taking custody away in situations where we may actually be looking at normal signs of childhood development. For example,
Counsel, what authority do you have for the proposition that parental alienation is a scientific conclusion as opposed to a legal one?
Well, I don't know what else it could be. The term parental alienation is one used throughout the nation. It's in law review articles, it's in treaties, it's in journals. And parental alienation has a very significant meaning that children were alienated mentally as opposed to physically, because we can't argue in this case that there's been any physical alienation, because the judge stated that the children hadn't lost any time with either parent. And in this particular case, if we focus on the mother, there's not even any indication that the relationship with the mother was damaged because of any of the things that the father had said or had done.
Can you point to me the exact place in the judge's findings that in your view show that the judge concluded that the children had actually been alienated, as opposed to findings that suggest that the father was trying to effectuate parental alienation?
Well, I think we look at the rationale. The judge said on page 24 of his rationale, the first full paragraph of the page, the judge says, not only is the father's parental alienation detrimental to the children, if we stop right there, he's making a decision that this parental alienation, these behaviors have affected the children in a mental way that has alienated them for the mother, despite the fact that there's no place in the record that suggests that the children are or have been alienated from the mother.
Well, he doesn't say detrimental. He didn't add the language that you just added in, which is detrimental to the children by causing them to be alienated from the mother. And there is evidence that, for example, the father's use of certain descriptors about the mother was detrimental to the children, in the sense that young children were using language that was not appropriate for their age.
I think one of the things that we should look at is the trial court attorney for Mr. BIORCI did an excellent job. The reason that I think that it's not relevant in this case is because we don't know what the child thought the word meant. All we know is that the child has heard the word, and the child told the mother that the child knew what the word meant. But nowhere in the course
From the father.
Correct. But difference to say that they heard the word versus heard the word as it relates to the mother, because that's not what the evidence says. What the evidence says is the father was from Australia, and the C word is a word that's used over there with regular occurrence. Now, whether or not the trial court believed in that or not, it's not really my point. My point is we don't know what the child thought the word was. So, for example, everybody on this call, everybody on this hearing, we probably all think that word is a terrible word and a word that you don't use. And that's fine. I actually think that from my own personal beliefs. Having said that, it's not relevant what any of us think the word meant or what it did. It's relevant what the child thought the word meant. And if the father said, hey, your mother is a C word, and the kid says, what is that? Well, it's a pretty flower, or it's what we all know the word to mean. We don't have the basis of understanding what the child thought the word meant. So therefore, we don't know if that word had any impact whatsoever.
But nonetheless, the child's use of that word is detrimental to the child, because how old was the child in this case at the time that the child used the word?
I believe 10 and 12.
All right, so I think we can all agree that it's detrimental for a child of that age to be using that word, even if he doesn't understand what it might mean in reference to his mother.
But to make the jump from being detrimental to affecting the relationship and terminating completely custody other than a supervised setting for 1 hour a week, I think is a very big jump. And one, quite frankly, that requires under the Daubert standard, some kind of an expert evidence to make that link between what you're suggesting, that word is detrimental. Words are words. The only time a word is detrimental if there's a meaning attached to that word, quite frankly. I could say 1,000 words to my children, and if they don't know what the word is or what it means, I don't know that you can argue without the benefit of some type of expert evidence that it had a detrimental effect and that it alienated the relationship.
But I don't see a finding of alienation, and that's why I asked you to show me the specific language, because where you point to right there is not, in my view, a finding that the father succeeded in alienating the children from the mother.
Well, if we also look at the judge's judgment, and what the judge, it's a 4-sentence judgment, and the judge says there is evidence that the father has disparaged the mother and levied false accusations against her and the new husband. And for a second, just keep in mind that all of that predated the filing of this modification. Then the judge says in the next sentence, this constitutes alienating behavior, which one or both of the children have had difficulty with this behavior towards their mother. Everything's talking about parental alienation in here. You can't take away that term from any of what the judge said, because it's all over here. He says that the GAL and the therapist used the term parental alienation, despite the fact that the therapist admitted during the trial that she had no idea or experience with that and had to go to Google to understand what it was before she used that term. And again, it's not just two words that have been put together. These are two words that have gone back over now probably 10 plus years throughout the United States of America and been used in many, many cases here. And in
let's say we take out the parental alienation. Let's say we take that out, because before the judge even talks about parental alienation, he says that the father's decision-making capability does not allow him to make decisions in the best interest of the children. And then he goes on to say that the father refused to acknowledge Zachary's the child's behavioral problems and engage in therapy. Father continues to focus on allegations of abuse, which have been determined to be unfounded by DCF and the children's therapist in the Tisbury police. He continues to attempt to document abuse by videotaping the kids. All of that has nothing to do with parental alienation. Are you saying that that's not sufficient for the judge?
I am saying that's not sufficient for the judge, because all of that taken independently, let me take one at a time. For example,
let's take them collectively.
All right. First of all, I don't think that those rise to the level of terminating custody. There's other things that or in this particular case, 1 hour of supervised visits and eliminating physical custody. There's many findings I would suggest in this case. For example, the judge said the court finds that the children have a strong bond with both parents. The court finds that the children love the mother and the father very much. How can you have this strong bond if the things that you're talking about have affected these children to the point where they don't have that relationship? In fact, it's actually better than that for the father, because if you look at the issue on the wooden spoon, when the father threatened to hit the child with the wooden spoon for discipline, and I'd note that he didn't hit the child, he just threatened to. The children had enough of an ability and a relationship with their mother that the first thing that they did was they contacted their mother and said, hey, mom, dad, they called him from dad's house. Mom, this is what's going on. We're afraid. So I would suggest that that's the opposite of alienation.
Isn't there record evidence that he did hit him with the spoon or no?
No, there was evidence that he threatened to hit him with a spoon.
I thought one of the children told one of the therapists that the father had hit them with the spoon.
Well, the evidence in the judge's rationale and the judge's findings was that there was a threat to hit him with a wooden spoon.
But regardless of whether the father succeeded in alienating the children's affection from their mother, it doesn't take away from the remainder of the findings that bear on the father's ability to parent the children. Or that's, I think, the crux of the problem for you, is that the judge made a lot of other findings that bear on the question of custody.
And I would suggest that every finding that he made was tied into the conclusion, and that's the problem, because we don't know. If we don't know well, that's not true. We do know what the judge was thinking here because we have a rationale. And while I agree that all of these things are lined up in the judgment and the rationale, all of these particular things that we speak about are connected directly to this finding of parental alienation, that the children's relationship with the mother has been detrimental because of the father's actions. Again, the only evidence that we have that he used the C word as it related to the mother in front of the children was in 2014, prior to a previous modification, which that was heard in which the father lost some of his time with the children. Now we're bringing it back again as the only time that the father said something in front of the children. It was in that 2014 date. Saying the word is constitutionally protected. Saying the word in front of the children is problematic, certainly, if that in fact occurred. And what we know from the transcripts is that it was alleged to have occurred one time prior to the I believe it was June 23rd, 2015 judgment of modification. And that word was used in the presence of the children in 2014. But I don't believe that anywhere in here that we have that word being used after the date of the filing of this.
The judge says in 2016, one of the child told mother what the word means. And when mother asked the child how he knew what the word meant, he replied, because dad says it all the time, and I asked him what it meant. That was 2016.
Understood, but there's no allegation that the father called the mother that word in 2016. And quite frankly, as I mentioned earlier, we don't know what the child thought the word meant, which would have been very important. And the trial court judge for Mr. BIORCI made the objection for hearsay. The trial court judge said, you're right. So had they brought the child in, or had the child deemed unavailable and was able to testify, certainly okay, but that's not what happened here. We're going
to have to leave this here because your time has expired, but I'm going to see if there are any other questions. So hold on. Yes, Justice
I have
Brown.
a quick question. Counsel, I understand you argue in your brief that the GAL and the younger son's therapist were not qualified to opine on parental alienation by virtue of their training and experience or their credentials. Where in the record does it say what the GAL's credentials are? I could not find it anywhere in the record appendix or in her testimony, though I did notice that the therapist has a master's in clinical mental health.
I think that's the problem, Justice Grant, is that there was no qualification of either as an expert, so therefore there was no voir dire or litany of what their qualifications were. So that is part of what our issue would be here, that these people made statements that the judge clearly relied upon throughout.
Wasn't it your burden on the, wasn't it your modification complaint?
Correct, but we had no
So
knowledge.
who had the burden on that?
well, because there was cross complaints for modification, on that one, the burden would be the appellant versus us, the appellee. So there was cross motions, there was cross complaints for modification here. So, and we had no notice that there was going to be any expert testimony or any expert issues, because none was set forth anywhere. So in
Okay,
hindsight,
let me see. Are there any other questions? All right, we'll have to leave it there. We appreciate it. We have your argument. We have your briefs.
Thank you.
Attorney Jackson?
You're on
You
mute,
need to
Attorney
come up.
Jackson.
Good afternoon, Your Honors. The court did not abuse its discretion in finding that a substantial change in circumstances existed in this case that warranted a change in custody to the mother. The touchstone inquiry is what is in a child's best interests. Here, the court found that communications between the parties broke down, that the father refused to acknowledge that there was no abuse occurring in the mother's household or by the mother's boyfriend. The father continued to use derogatory language, and more importantly, he didn't acknowledge that it had any effect on the children. The father refused to participate in one of the children's therapy in any meaningful way. And the children were expressing fear of the father, and there was an admission by the father that he was tapping the children's behinds with a wooden spoon. The court also found that the father's decision-making capability does not allow him to make decisions in the child's best interests. And the most important example of that is that this father has not exercised his parenting time with his children since June of 2017, only because father does not agree with the supervised visitation center's policies and rules. The court properly took into consideration Chapter 209S, Section 10, which mandates that the court must consider past and present abuse. The court did find that mother's relationship with the father was physically and emotionally abusive. The court took into consideration whether the parents were able to successfully exercise joint responsibility and whether both or either parents were able to subordinate their needs to those of the children. The evidence in this case was clearly overwhelming that the children were in harm in the father's care and that he was not able to make decisions that were in the children's best interests. In regards to the issue of parental alienation that's been brought forward, it's immaterial and no consequence that the described conduct of fathers or fathers' pattern of behavior was simply an ancillary finding or a description that the court used. Expert testimony is not always required. It's also worthy to mention that there was no objection at any time in the lower court in regards to any evidence of parental alienation. And it came in a myriad of ways, through testimony of 3 therapists, through therapeutic and mental health treatment records of the children. The judge himself found that the father was coaching the children in an audio tape that the father actually had admitted into evidence and presented, wherein the father explains to the youngest child, who at that time was 8 years old, what an assault is, allows the child to use derogatory language at the court and to their stepfather, the mother's husband, and does not turn the children away from doing that. And after that ended, that audio tape, he allowed the children to have a sweet Milo drink and play with puppies. There was a therapist, Carmen Wilson, who reported that father was present during his therapy sessions with the children, that he actually coached the children. The therapist reported father manipulated the children against the mother. That was one therapist. Another therapist, Chloe Tagan, testified that one child was being influenced by father. And a third therapist, who was involved with one child for 2 years, who had a psychiatric diagnosis of adjustment disorder, said that she began to be concerned that father was alienating the child because the child was afraid to say anything positive about mother in the session when father was present, but also outside of this session, the father had told her that he wanted revenge. Also, the father, there is evidence that the father was bringing these false allegations both to the therapist, Ms. Wild, and her agency. And actually, he brought 5 false allegations of neglect or abuse by the mother in the mother's household over a period of about 4 years, all of which were unfounded. In fact, the only supported 51A for neglect in this case was by the father in 2014. You know, the father filed this complaint for modification, and right in the 4 corners of his complaint, he actually alleges not just currently the children are being mistreated in the mother's home, but that there are incidents and dates that establish an ongoing pattern of conduct that predate the complaint for modification. And he almost simultaneously went to the town police with this same audio tape that the lower court judge heard. And when that police officer made the determination that the tape did not constitute any type of evidence of abuse, the father told that police officer about all those prior incidents and created another new body of evidence and another investigation, a police report that's part of this court's record as part of the DCF file, the Garnett-Ladham's file. And after a second investigation that was very lengthy and was over 20 hours by a Tisbury police officer who testified at trial, as well as her report came into evidence, found that all of those allegations were unfounded. In regards to the use of derogatory language by a parent, even to a third party, that's certainly a factor that a trial judge hearing a custody case can take into consideration. They can take into consideration any party's behavior, including disparaging language, may be factored into a custody decision, and it should be. In this case, there was overwhelming evidence. The judge made 113 findings. There were 9 days of trial, 40, I believe, 5 exhibits, and 17 witnesses. And there was no objection to any of the parental alienation characterizations or descriptions of anybody's testimony, or no motions to strike in the lower court. And when I look at the actual findings from the Garnett-Ladham found that one of the children was afraid to even speak with her or make any statements to her in her 3rd investigation. Now, after 3 investigations, the Garnett-Ladham had a relationship with the child. She testified, the judge found credibly that she believed the child was afraid. And then the Garnett-Ladham's finding is not like a psychological conclusion or a psychiatric diagnosis. There was never any mention of a parental alienating syndrome or anything like that. She basically found an observation, and her observation was after completing 3 Garnett-Ladham reports, the investigator determined that after 3 investigations, father attempted to alienate his children. And that was after she interviewed all the child's therapists that said that he was manipulating his children against the mother and coaching them. And the judge even found that he was coaching the child inappropriately. In regards to the argument, the derogatory words to third parties, clearly the father's words were not protected by the First Amendment. I mean, they were defamatory in nature. But even if they were protected, the court in its decision did not do anything that would violate father's First Amendment rights. There wasn't a non-disparagement clause that the court issued, or there wasn't any prior restraint, although in my counterclaim for modification, I had asked for one. The court declined to enter one. The court merely took into consideration the observations of the father's behavior and how those observations impact the children, which clearly they do. If someone is saying derogatory words about the mother, and mind you, it was in Tisbury, Massachusetts, in a small community that has about a population of 4,000 people, not only indirectly is that affecting the children because the mother is upset, but it's directly affecting the children's family and family's reputation, and perhaps even the children's feelings about their mother. And there is a compelling interest to protect children from emotional and psychological harm from anyone. And certainly that would be the role in a judge hearing a custody matter, taking into consideration all the factors, any factors. The court has really a lot of discretion to deciding what factors and evidence to take into consideration and what the nature and scope of that evidence is going to be in order to formulate the correct decision as to what is in the children's best interest. And the judge in this case did that, and his decision should be affirmed and upheld, and the mother should be ordered appellate counsel fees.
Let me, we understand your argument, and let me see if there are any questions. No, I don't see any. So unless you have anything further to add, we have your briefs, we have your argument. Do you have anything you want to add at this point?
No, Your Honor. Thank you.
We appreciate it. We appreciate all of your arguments. The case is interesting. Your arguments helped us, and the case is submitted. You're welcome.
We are live and on the record.
Good afternoon, and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we're conducting court in this fashion, all the ordinary rules of oral argument apply, which includes that each side receives 15 minutes to argue with no rebuttal. With that, I will call the case of SS versus VS, case number 2019 P 1644. I will remind counsel that the case is partially impounded and to therefore not use proper names. We are ready whenever you are, Attorney Mateus.
Thank you, Your Honor. May it please the court, John Mateus for the appellant VS. In this matter, the parties, this is a domestic relations matter, a divorce. Is that the underlying, I represent, it was a husband and wife. I represent the wife who was appealing. And so I refer to them as the wife and the husband. And I represent the wife. In this matter, Your Honor, this regards the interpretation of a subsequently filed DRO amending the property rights to a separation agreement. By way of brief background, in 2014, the parties divorced. They signed a separation agreement. And in that separation agreement, there was a clause about the division of the husband's pension plan. He had a government pension plan. And in that government pension, and in the terms of the original agreement, and this is found on page 26 of my appendix, which is the relevant language here. The parties agreed, the separation agreement states as follows. The parties agree to use Glenn Berger to draft a qualified domestic relations order, or QDRO, with the wife receiving 30% of the value of the marital coverage share of the husband's pensions, such benefits to be paid to the wife upon her obtaining a retirement age of 66 and a half, which would occur in January 2030. 4 years later, also I would point out that this separation agreement also had a couple of clauses. One of them was that the property division of the separation agreement would survive as an independently enforceable agreement, which would include the agreement about the separation of the husband's pension. And also in terms of modification.
So can you just run through for us in the abstract, what was the required procedure where the provision at issue here survived the judgment for obtaining a modification of that surviving provision? What needed to be done as a matter of practice?
as a matter of practice, the parties needed to file an agreed upon amendment signed by both parties, and either it would be acknowledged or it would be approved by the court as an order of the court. In this situation, the latter circumstance occurred, which was this party submitted a modification to the court in 2018, and the court signed off on it. I believe it was March 16th of 2018. It was March 2018 when Justice Vargas herself signed off on the modification. So
Well,
the modification.
Signed off on the motion, was there an amended judgment?
No, Your Honor, there was no amended judgment filed.
So, so what effect then does signing the amended, signing the joint motion have if it doesn't, amend the judgment?
By signing the motion as filed, it becomes an order of the court, which modifies the original, which modifies the separation agreement that has survived.
But it didn't become part of the judgment.
According to, if I may read from Justice Vargas's opinion here, and I'm just looking quickly, Your Honor, but when she did, there's no requirement in the original separation agreement that it needs to amend the judgment. All it needs to be is that an order of the court creates the modification. There's no requirement in that modification that it has to be a statement of an amended judgment.
Okay, so so I guess where things stand at this point is that when Judge Vargas approves the joint motion, that operated as a, I guess, order approving the joint motion.
Yes,
but
Your Honor.
the judgment remains as it was earlier.
Well, yes, we're not modifying the original divorce decree. We are modifying the separation agreement, which is independent.
So there's been no approval by the court of the modification, as I take it.
Well, the modification does not need to be approved by the modification does not need to be approved by the court because we're not amending the original judgment decree. We're modifying an independent agreement, property rights division.
Right.
And so the signing off on this motion is an order. The agreement of the judge to this motion is an order of the court, as we would say in any situation where a party made a motion and the court agreed with it and allowed it. That would be an order of the court.
You previously characterized it as an amendment. Are you moving away from that now?
It is amendment to the property agreement. It's not an amendment to the original divorce decree, Your Honor, that's better clarification.
Or to the judgment, right? So, which may be
The original judgment.
Yeah.
This isn't a judgment to the property division that has survived.
All right, so then take us to what happens next.
In 2018, the parties come to an agreement, signed at arm's length, both represented by counsel.
No, I mean
that
after this point, procedurally.
Oh, procedurally after March 2018, what
After
occurs
the
is
judge approves the joint motion.
after the judge approves the joint motion, procedurally what occurs is the husband claims on December 27, 2018, within a year, that he had received word from the State Board of Retirement that immediately the wife would begin to receive 47.9% of his retirement benefits.
And that motion is, we understand, we've read the briefs and the record, but that motion was made under pursuant to which rule?
He claimed, well, it isn't clear, but he claims mistake.
It's a motion to vacate. It's a motion to vacate, I suppose.
Yes, it's a motion to vacate based on mistake.
The previous order.
Yes, the previous
Okay.
approval.
So are you maintaining an objection to that procedure, to the procedure by which the husband?
That is part of our argument, Your Honor, because
okay,
there's
so
no.
tell me.
Well, Your Honor, it's quite simple. The husband's argument was that there was a mistake in the negotiations between the parties, and that the agreement was a mistake, an inadvertence. However, as Justice Vargas herself stated on the record at the oral argument on this on New Year's Eve in 2018, that it's very clear and unequivocal, the language of the DRO that was filed in 2018, that she's going to receive.
I'm sorry, that seems to talk about the merits. Procedurally, what should they have done, if not what they did?
Well, Your Honor, procedurally, if the husband had an issue with the agreed upon amendment, there were a number of things. First of all, he could have renegotiated with the opposing side.
What should he have done? Not what could he have done. What should he have done from your view?
Your Honor, from our point of view, there is no challenge he could have made directly to the agreement with the wife, because they had agreed this at arm's length and they had dotted all their I's and crossed their T's. They had gone to court, had it approved. As far from the husband to the wife's point of view, there's really no recourse. There were other things he perhaps could have done.
Why couldn't the husband, what precluded the husband from going back to the judge in order to modify what was only a previous order approving a joint motion on the basis that the joint motion was the product of mistake? What rule precludes that? Not some argument about the merits. What rule?
Your Honor, most respectfully, I cannot think of a rule that would disagree with that. You had the right to go to court with that.
We're trying to figure out, because your brief appears to argue that there was a procedural defect. There's a procedure that somehow prevented the husband from seeking relief in the way that he did. And we're trying to explore that now with you to find out what rule you're relying on.
I believe if that is the court's reading of it, I apologize. That was incorrect. It should go to the merits on this one, that there was no meritorious reason for bringing this. Procedurally, you can bring a number of arguments against a motion, but my brief was to the merits, that there was no mistake that would have granted him this relief. There was no mutual mistake or inadvertent error.
Well, is there anything in the record to explain anything that happened between 2014 and 2018 that would have caused the parties to do what you call this arm's length renegotiation from 30% to 47.19% of his?
There's nothing. No, Your Honor, there isn't. And there was no evidentiary hearing called by the judge to determine that.
So we have no reason, we have no explanation as to why the husband may have gone along with that new provision. Instead of 11 years later paying at 30%, he's agreeing to now pay 47% immediately. We have no reason, no explanation or renegotiation.
We have nothing. The only thing we have, Your Honor, and I agree it's not much, is the statements by the husband's counsel at the oral argument stating that this was an error by an associate of the firm who had put that language in and not understanding that it would be paid right away. That was a statement made by counsel, not under oath, but other than that, nothing else, Your Honor.
And so to that you say, too bad, so sad, but that's not good enough.
No, Your Honor, definitely not. It's not good enough to overcome this. Not when they were signed documents submitted to the court with lawyers reviewing them. No.
What's our standard of review for that?
De novo, Your Honor. That's Tompkins.
Why?
Because you are interpreting contractual provisions, and when
no, I don't understand why it's a contractual provision. We're talking about mistake in entering into the agreement. We're not talking about the meaning of the agreement itself.
But there was no evidence presented about what mistake occurred. He merely stated, in fact, Justice Gargas on the record state, it's clear and unequivocal. You can't argue a mistake here. That, well, she doesn't say use the words, you can't argue a mistake. But she says this is clear and unequivocal on its face, just as was the case in Tompkins v. Tompkins. There's no way, just because the attorneys or the husband misread these provisions and they claim mistake, does not mean that this mistake was the kind that under Rule 60 here grants relief.
Well, it's not, as we already established, it's not a Rule 60 situation. There was no change to the judgment. As far as I can tell, the judgment is still the original judgment.
Yes, Your Honor, we're only modifying the property arrangements.
But you didn't, all right, we don't need to keep going around in the same circle.
And Your Honor, just moving forward, this is not an unconscionable provision here. They increased it to 47%. It's not all of his retirement funds. It said it when it was feasible. The state board apparently told him it would be administratively feasible at the end of the year. This is not something that was unfair surprise or hidden in the contract. And
why do you say the state board apparently told them that? Why do you say that? What do you point to?
Because the husband claimed in his motion and at his oral argument that the state board had, very shortly before he filed the motion, informed him that they was going to immediately start paying the wife the retirement benefits. And that was the trigger to him to file the motion, because he did not want the retirement benefits immediately starting to pay out. Again, no evidence was presented besides the statements of counsel and the motion papers. There was no documentary evidence filed on this point. So we're basically going on the arguments of counsel here. And Your Honor, just as one point, opposing counsel has raised the issue of frivolous appeal here. We strongly object, and we've actually filed for frivolous appeal on that, because quite frankly, the very fact that we're having oral argument on this issue and arguing about case law, Tompkins v. Tompkins, whether it applies and how much it applies here, shows that there's a valid meritorious issue. And the entire basis of the frivolous appeal argument was that these arguments were made in front of the trial court. The trial court rejected them. Therefore, this appeal is frivolous. No case law cited. That to me is gumming up the system with needless charges and frivolous appeals. And that's why that should be dismissed, and a frivolous appeal should be instated against them for making such an argument here. I've made many arguments on appeal and opposing in many cases, and I've only once charged the opposing counsel with frivolous appeal, because most of the time everyone's appeal arguments have some merit to them and deserve to be heard. And if there are no other questions.
Let me check. No, I think we're all set.
Then I rest on my briefs, Your Honor.
Thank you.
Thank you.
Attorney Eisenman.
Thank you, Your Honor. Good afternoon. May it please the court, Lynn Eisenman on behalf of the husband. Just from a procedural background, I just wanted to point out that when the motion to approve the domestic relations order was submitted to the court, it was handled administratively. So there, as you can see from the docket, there was no actual hearing on that motion when it was allowed. And I will point out that the motion itself only asks the court to allow the domestic relations order itself. There's no request in that motion that any judgment of modification issue that incorporates what my brother has referred to and as the amendment agreement as a modification to the underlying separation agreement.
So in your view, what's the procedural consequence of that?
That it is a document that parties unnotarized, not actually approved by the court. What typically would have happened, and I referenced in my brief Rule 412, that if the parties are modifying a judgment, they need to submit a notarized agreement. This agreement is not notarized. They need to submit, because this issue involves financial questions, they need to submit financial statements to the court so that there can be a review as to whether it's fair and reasonable under the circumstances. Ostensibly, if the court found that a hearing was necessary to go through a colloquy with the parties, the court could have scheduled a hearing. So from my client's perspective, it's a document that exists and was attached to what was filed with the court, but it, for lack of a better description, sits there and is not incorporated into a judgment of modification. So it's of no effect. And then the husband goes in on a motion for relief from judgment, which I think is, although it's not titled that, I think that's how everybody treated it under the circumstances, including the wife in her opposition and the judge in her findings, under Rule 60B. And that is what triggers the standard of review of whether there's an abuse of discretion in the judge
But
vacating the order.
Why would Rule 60 be the appropriate mechanism when there's been no modification, in your view, of the existing judgment, which goes all the way back to the original divorce?
Because we still have the order that allows the motion to approve the domestic relations order. So that order is still sitting there.
But do you
and docketed.
Do you use Rule 60 to vacate orders?
You do, yes. It's titled motion release from judgment or order.
Okay.
So because of the mistake that's contained within the document itself, it can come in under Rule 60B. Even though there was no judgment incorporating the terms of the domestic relations order. And so because that's what the parties were in on procedurally, the standard of review is an abuse of discretion. And I think the case law is clear on the standard of review on post-judgment motions or order motions to vacate an order. And I will say that I know the wife relies extensively on the Tompkins case in her brief. I will say that this case is in a very different posture procedurally than that case, because this motion, in this case, was timely filed. So it was about 9 months or so after the order was issued. In Tompkins, 4 years later, the husband sought to go in and essentially vacate the quadro in that case. And in that case, the appellate review was looking at the order de novo because the trial judge essentially looked at his pleadings as a complaint for equitable relief and an interpretation of the agreement, which is not what we have here. We're looking at a document that was filed with the court that contains a clear error on its face, and I think that's what the judge was relying on. And I will also say that there was no consideration for this alleged modification that the wife says existed.
Now, there's no evidence put before the judge, right? So when you put things in like there's no consideration, there's no evidentiary record before the judge, was there?
There was not. There was not. It was apparent on its face, though, and I think that the court could have, would have looked at the underlying separation agreement and saw that the division that was set forth in the agreement, which was 30% payable in beginning in the year 2030, versus what the wife was claiming was an amendment to that, which was essentially a more than 50% increase to 47.19%, and then starting immediately 11 years earlier than what was in the separation agreement.
I'm not quite clear from your brief. Are you challenging both components of this amendment, the increased percentage and the timing of the payout? Because it looks to me at some points that you challenged only the fact that the retirement board was going to start paying it out immediately.
Oh no, I'm challenging both, and I'm saying that there was no modification of the underlying separation agreement, which was 30% and starting payable in 2030.
So the entire thing, in your view, is a mistake?
Correct. Yes. And it's the two provisions in the domestic relations order, paragraphs 5 and 6, on page 33 of the appendix. It's the amount of the benefit and also the commencement date, because that's what the wife is alleging was changed as between the parties.
I mean, I have to be frank, I'm having a hard time understanding how a lawyer signs off on. Are you saying that there was no agreement to modify in any respect?
That's correct. And I think, and from the transcript.
How do you explain a mistake of that magnitude by counsel? That's not
So-
clear to me from the transcript.
So in the transcripts, trial counsel told the court that it was her associate's mistake, and that she took full responsibility for it. It was, she acknowledged the mistake and that she had failed to catch it.
But catch a
And so-
mistake sounded to me like a mistake in the terms of the agreement, not that there was an agreement at all, that nothing should be filed. And you'll have to show me what portion of the transcript you're relying on.
Sure. What she was talking about, the way that I read the transcript, is that she was talking about what was contained in the domestic
Which page
relations
are you on?
order. One moment. It starts on page 7 of the transcript at the bottom line 21.
Okay, I'll take a look.
And then it goes into the following page. And as the court found, consistent with that representation, that it was a clear error in the face of the document, meaning the domestic relations order itself, and that there was in fact, and the court goes on to say, there was in fact no amendment to the underlying separation agreement. No modification judgment had issued. There was no notarized agreement as between the parties, no financial statements filed, nothing of that sort.
Counsel, where did that number 47.19% come from? That seems like a very specific number to be a mistake. Is it from some other case?
Your Honor, I don't know exactly where it came from since I was not involved at the trial court level. So I don't know, and that was not before the court, but I think that the point was, in reviewing it, it was such a drastic difference from what was agreed upon in the separation agreement of 30%. But there was no evidentiary hearing requested at the trial court either. So the court was taking the representation.
But at this point, it's your client's motion. So really the burden is with you to put forward the factual evidence that was required.
Correct. And I think that trial counsel,
I mean, here's what I'm looking at, and I'm looking at those pages of the transcript. She says it modifies the addendum. If you read it, does not say that it modifies the terms of the separation agreement. It modifies the terms of the quadro. She thought this actually fixed the problem. Had it been brought to my attention, I would have seen that it did not. And then it goes, it's ambiguous on his face. She's not saying, I don't hear counsel telling the judge, this whole thing is a mistake. No one agreed to change a thing. None of this should have been filed at all. The mistake appears to me to be some sort of drafting mistake that she's telling the court about.
Well, she says there were no actual negotiations that went on.
Right.
Nothing exchanged.
I mean, she says, my associate believed that this amendment would convince the state board to actually follow those terms. The state board will not follow those terms. I don't understand that explanation now.
I think she was trying to get across that everything that was submitted to the court was a mistake, and that it was not what was actually supposed to happen either under the agreement, the underlying separation agreement, or that there was in fact a modification. Because she's acknowledging she does say the separation agreement itself says that she's supposed to get 30%.
When counsel below says, I understand for some reason my associate thought that this amendment would solve the problem, what was the problem that the parties were trying to solve?
So I don't think that that was before the court, but the way that I understand it is that in drafting the proposed quadro up until that point, that it had been drafted by an outside third party with a 50-50 division of the pension instead of the 30-70, which was supposed to happen. But nothing had been submitted to the court with that because it wasn't correct. And so the only other piece I would add on this is that, you know, I think it was telling that the court, that the trial court found that stated that she did not find the wife's argument to be meritorious or brought in good faith, which is why I had requested appellate counsel fees, because that same argument is being advanced again. And when there's a specific finding to that effect, that's important. And I think that the trial court was in the best position to judge what was before her and the arguments that were being made. And so if there were no other questions, I would rest on my brief.
I don't see any. Thank you. It's an interesting case and we appreciate your argument. We've been helped by it. So the case is now submitted. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.